And we will get right into it. Oh, there we go. Golan, Michelle, happy
Hey,
Tuesday. Happy almost after hours.
hi
Yeah,
Joe.
good. Nearly there.
We're
Hi
nearly there.
Michelle.
We are nearly there. Um, Big
Well,
topic to discuss tonight. Big game to watch later. I know Michelle and Golan are both avid fans,
Yeah.
and maybe the participants
we
are
thought
too. I
we
don't
thought that
know.
the subject matter of today was game five. What's gonna happen? Play some bets. I don't know. It's
I would
We
have
should put a
loved
poll in the
that.
chat and see what people say.
Yeah, exactly. And whoever's a Sens fan, we boot them.
Which is
We
good.
boot them out of the seminar or the webinar for today. No, but thank you everyone for joining us today. It is 4:59. It's not yet. Oh, we're 5 o'clock. We're after hours. So we'll just get right into it. So everyone, welcome on Zoom, on YouTube. Welcome to Family Law Now After Hours. Uh, Today's topic is how to file a motion to change. And as always, please note the purpose of this series is to discuss general information on separation, divorce, and other family law matters, and that any information provided here should not be construed as legal advice. If you are joining us via Zoom, please use the Q&A feature to submit your comments and questions. Unfortunately, if you're watching us via YouTube, you do not have that function or opportunity. But if you are on Zoom, we welcome your comments and questions, and if we can get to them, we'll most certainly do so. But if you have questions regarding your specific matter, it's always best for you to please call our office or a lawyer in your area to book a consultation to be able to receive tailored advice. And as always, stay tuned until the end as we will be sharing how you can schedule a free initial consultation with one of our lawyers here at Russell Alexander. Now on to the bios. You have three, I'm including myself, three amazing people on your screen. The first is Golan. Golan is an associate family lawyer and a certified mediator with over 25 years of legal experience. He was first called to the bar in Israel in 1996 and then called to the bar of Ontario in 2003. Golan has extensive experience in representing clients in negotiation agreements as well as trial work. He also has experience in negotiating with the authorities to advance a client's interests and has represented clients at various levels of court, including on appeals. We also have Michelle. Michelle's worked as a law clerk exclusively in family law since 2014, and she joined Russell Alexander in September 2017. As a law clerk, she works closely with clients to draft various correspondence and court documents, and Michelle is also committed to providing professional and compassionate assistance to clients, ensuring their needs are met with precision and care throughout their legal process. As for myself, I'm a compassionate family lawyer driven by a deep desire to support families through challenging times. And with a background in commerce, I bring strong negotiation, analytical, and critical thinking skills to my legal practice. During my articling period, I gained confidence in handling a wide range of family law matters, and I emphasize active listening, clear communication, and empathy, fostering a comfortable environment for clients. I am too certified as a collaborative lawyer with the Ontario Association of Collaborative Professionals, and thus I offer clients an alternative dispute resolution approach to avoid court. Outside of work, I am a dedicated Toronto Maple Leafs fan, i.e., the jersey, and LA Rams fan, and enjoy playing hockey and watching comedy movies. So, with that, let's dive into our first topic of the day, and that is when a motion to change is necessary. So, a motion to change. So, first, before even understanding when it is necessary, um, it's probably a good idea to understand the definition and what exactly it is. So, a motion to change is a legal procedure and it is used to request modifications or variations to an existing family court order or a written agreement that's been filed with the court. Or may not have been filed with the court, but there is an existing written agreement, whether that be a parenting plan, a separation agreement, a prenuptial agreement, a postnuptial agreement, anything that can be classified as a domestic contract within the Family Law Act. Common areas for such motions include child support. So this can be adjustments due to change in income, employment status, or the child's needs. Spousal support, so it can again be modifications based on significant financial changes or life events, as well as parenting arrangements. So this can be alterations in decision-making responsibility or parenting time. And these are just again some of the common areas, but of course there's others. And to initiate a motion to change, there must be what's called a material change in circumstances, since the original order or the agreement, whether again it be a separation agreement or a prenuptial agreement, whether when that was made. And the change needs to be substantial, unforeseen, and affects the conditions under which the original order or agreement was established. And sometimes we have clients coming in and saying, what exactly could those material change in circumstances be? And examples include income fluctuations. So it can be significant increase or decrease in either party's income. And, again, that goes towards either child support or spousal support issues. Employment changes. So it could be a job loss, maybe new employment or retirement, again, having an impact on child and spousal health issues. So there can be a serious illness or disability impacting a party's ability to work or care for children. Relocation is one that's common. For example, one party moving to a different city or province, thus affecting parenting arrangements, whether that be parenting time or decision-making responsibility. There can be changes in a child's needs, so evolving educational, medical, or even extracurricular requirements that need to be um, modified or varied based on the change in circumstances, as well as parenting time adjustments, so significant alterations in the amount of time a child spends with each parent. And it's really important to note that when you're bringing forward this material change in circumstances, an assertion is usually not enough. And it's really important to note that when you're going through this process, the court requires evidence of these changes and that they significantly impact the original order or agreement's terms. So these are all things to be considered. Golan, Michelle, any thoughts or additional
Yeah, I mean,
comments?
you just mentioned the idea of when motion to change is necessary. Um, I think it becomes necessary when the parties are not able to agree on the change. So perhaps the idea to let people know is that you don't have to jump to a court proceedings, and there should be some record indicative of attempt to vary or change the agreement or the final order with the explanation of why, giving the other side the option of putting the input in, showing the resistance, opposition, or perhaps further adjustment. But assuming that it fails, and sometimes even when it doesn't fail, you can have a motion to change on consent. So, you can consent on the changes to the terms of the parenting plan or the child support, and you want to codify it in such a way that it would be enforceable. Therefore, you go to court with a consent to a motion to change. So that's the just kind of preamble to when you actually moving to court. But assuming that it's more, we're looking at a situation where it's more adversarial and there's opposition, then of course you gotta have the backup to your position of change. So whether it's going to be your financial position has changed and you want to maintain your records of employment, if you received if you were terminated, if there was a change in the contract of employment, if there was a new pay stubs, new job, all of these things gotta be part of the record that you want to be able to produce soon after the filing of the motion to change. In fact, you would want to share some of these material before you even start the commencement of the proceedings, because you want to be able to convince the other side that a change is necessary, it's justified, it's reasonable, it's not an attempt to manipulate, and it's all genuine. So gathering the necessary information that would include, like I said, all financial records that are relevant to the situation, maybe a school records or medical issues that relates to the children, relate to the therapy, relate to counseling. All of these things may require or you may be relying on when you come to ask for a change or you want to prove that material change has occurred in the circumstances. So yes, that's the type of thing you want to see that you have in your back pocket ready to go and produce. So you're also preventing the delay in the process of producing all of these records. If you have to attend your bank or if you have to request the information from a third party, all of this would be part of the homework that you should do prior to commencing proceedings. That's kind of as a start and consideration of should we go to court. There is still expense to that issue. Even if you're going to do it by yourself, it's not always the easiest thing. It's very technical in nature, whether it's the forms that you have to use or whether it's the test that Joe, you just mentioned earlier, the material change as opposed to just a change, or foreseeable change versus unforeseeable change. All of these things that are technical in nature and one have to consider. And in my view, it's always better to at least have that initial legal advice before you bounce onto the litigation stage.
100%. And I mean, let's just say you've retained a lawyer, you've had this conversation with a lawyer, you've tried to resolve the matter in an amicable matter outside of court, but we've gotten to the point where we don't see a resolution outside of court being likely, and thus we're going to have to actually take that step to commence a motion to change. Michelle, can you explain what forms are necessary in order to get the process started?
Yeah. Yeah, so it depends. So first and foremost is your Form 15 motion to change, which is the meat of the matter. That's where you're going to be outlining the orders that are in place and what you're seeking to change. In support of a Form 15 would be if you're seeking change to parenting time, you're looking at a Form 35-1 affidavit, which would support the claims that you're seeking to change regarding parenting time and decision making. And then there's also a Form 13 financial statement, which you'd use if you're making claims for changes to support. When we complete these documents, there's often a few pieces of information that, we signed off on the 15B, just 15. We're ready to go to submit the documents. And then we remember, did we do a confirmation of assignment? If your matter is requesting a change to support, a confirmation of assignment needs to be obtained, which is a form that's submitted to the government, and they produce a form that's just advising whether or not the support order is assigned to a government agency. Oftentimes, it's relevant when the support recipient is in receipt of welfare. Then there is often an assigned party, which would then need to be served with the motion to change. So the court wants to see that you've requested that confirmation. As well, if there's any arrears of support owing. If there's not arrears of support owing, but if there's a support order in place, you need to request a statement of arrears from FRO, the Family Responsibility Office, and attach that to your Form 15 as well.
So we've filled out all these forms. We've done the 15, we've maybe done the 14A to accompany the 15. It's dealing with maybe child support issues. So we've done the 13 or the 13.1. We've done the assignment, the confirmation of assignment. We've done all these things. How do we now get them to the court? Where do we go from here?
Yeah. So everything's done virtually nowadays. But anyways, so we would go ahead and swear your documents with you. The next step would be to submit them through the JSO Justice Services online portal, not a portable, a portal, and submit them for issuance. You'd be submitting it to the court that has jurisdiction on the matter. Once you submit it to the court will take it, they'll issue the motion to change, and then from there, send you that issued document for service. Left out previously, but also make sure you have a copy of your final order, because that would also be required to send to the court. And then if you're issuing your application or your motion to change within the same court that you were previously, your matter was previously in, for instance, if you're seeking a motion to change to a court order, the court file number assigned would be an extension of that same court matter. So they're essentially tied together a little bit there.
Joe, this is how you're speaking to a professional, because she's just saying it just from the top of her head, assuming everybody knows what she's talking about. But that's the technicality that I was talking about earlier, that there are so many forms, and you have to make a decision about what am I asking for? Is it has to do with support? Do I have to just file a Form 13? Does it have to do with spousal support? Do I have to file a 13.1? Do I have to file the affidavit in support of parenting? Is that so? There's a lot of moving parts that one needs to decide on, and every bit of it, if you don't do it right, it's just going to be rejected. You have to come back, and so when Michelle's saying, "Oh, it's going to be done virtually through the portal," trust me, even I don't understand what it means, because I avoid doing it. But the idea is, firstly, people, I mean, if they're doing themselves, they have to set up their own account for the portal, and that has to be done online. They have to investigate that whole issue. It's not an easy process. It's sometimes frustrating, and those of our viewers that may not be, tech savvy, may want to go to court in person to try and there is that still option available for exactly that situation, that people can do it over the counter. Not recommended. It would be not liked by the court staff that all of a sudden somebody's at the weekend trying to file material. But that's on the technicality issues, because there's a lot of forms that you have to decide on. And you spoke about the assignment, so that has to do only if there is a change for child support or is a financial matter that is concerned. If there is no financial matter that is concerned in the motion to change, you don't need to file a financial statement. You don't need to file this assignment. So maybe less a cumbersome and kind of more straightforward, perhaps. One of the things that I mentioned earlier, before jumping into the court process, and I said, the first thing is, you better show some communication flowing between the parties to see that there was an attempt to do it outside of court. There is other alternative to the litigation, including the mediation, including a private arbitration. The process that Joseph mentioned as a collaborative process, at least as a skill that this firm possess and encourage many times, and it's working wonderfully with the right people involved. So that's just another kind of a dispute resolution options that are available out there. But Michelle, what you mentioned, absolutely, you can see that you better talk to Michelle if you need to file something. That's the bottom line here. Better call Michelle instead of better call Saul.
I'm a law clerk. That's what I'm here for.
I think that would be the best sure way to go, that you're not being rejected and being repeating the process again and again if you want to get things done. Yeah, that's my comment to that technical issue. Back to you, Joe.
No, for sure. There's so many moving parts, and I mean, us lawyers, we have issues filing sometimes and getting our materials rejected. So, I mean, the process for us is difficult, and we practice. Like, this is what we do every day. So, if you are a self-rep, if you are unable to secure legal representation and have to embark on this process alone, there are some great materials to reference. Whether our firm offers a lot of resources on our blogs and steps in which to engage this process. There's a lot of great resources online. So it is overwhelming. There is a lot that needs to be considered when you're going through this process. So it's really important to look at the fine details. And if you are available or able to even speak to duty counsel at the courthouse or even go to the courthouse, I know they're available 9 to 11, 2 to 4. COVID really put a hamper on when you can access certain resources, but 9 to 11, 2 to 4 for most courthouses. The Family Law Information Center is a great tool and a resource for self-represented litigants. We do have a couple questions flowing in. I'm just gonna pick up one that we can discuss. Someone asked, could a leave of absence be considered a material change in circumstances? Golan, is this something you want to answer?
Well, sure. A leave of absence has a reason to it. The reason could be mental stress, stress leave, all kind of situations that brought about the leave of absence. So if it seems like a voluntary action, it would be difficult to argue, oh, this is a change of circumstances. If you are the initiating of the intentional unemployment in a sense. But if that unemployment is justified because of other reasons, and you somehow maintain your job through a leave of absence, and maybe that kind of maintain your spot, or maybe you'll be eligible for employment insurance. So it depends on the circumstances of why this leave of absence comes about. What's the surrounding circumstances, and whether the motivation is there to continue and uphold the existing arrangement, court order, or separation agreement, or whether there's an attempt to deviate from that by somehow losing your stream of income. Let's put it that way. So it's really a case and fact specific.
For sure, 100%. Always, every case we deal with is always fact specific. That's why it's very difficult for us to offer tailored advice on these webinars. So if you do have any concerns or questions about your specific matter, it's always best to retain a lawyer if possible. So segueing back into our conversation, Michelle's been able to file your materials. All your materials have been accepted by the court, and they've issued the materials to you. So you have the court stamp on top. It's signed by the clerk. You have these materials. Now, how do I serve this motion to change? How do I get it to the attention of the other party? So, with respects to a motion to change, it requires what's called special service. So this means that you cannot serve the documents yourself. Rather, it has to be someone who's 18 years of age or older. It can be a friend, it can be a family member, it can be a professional process server, which more often than not is the best route to go, is hiring a professional process server. But it must be personally hand delivered, right? The documents that you're serving have to be personally hand delivered. That's the idea of special service, and it's done via the other party directly or their lawyer if they are represented and you or your lawyer have confirmation that their lawyer is retained to accept service on their client's behalf. So ideally speaking, the standard practice is that you serve the other party directly, again through a process server. And with respects to special service and the way in which you are serving the other party, again through being personally hand delivered, this is the only valid method to serve a motion to change. So it can't be done through what's called regular service. It can only be done through special service. And again, we've already discussed some of the documents that are to be served, but that includes the Form 15 that you've been issued. So it's the motion to change that has the stamp from the court, the court, as well as the court signature or the clerk's signature. It also includes all supporting documents. So any affidavits you have or any financial statements that are incorporated as part of the supporting or accompanying materials. And then also you would be serving what's called a blank copy of a Form 15B. So that document, the 14B, is used if the other party wants to respond to your claim. They don't have to. If they don't respond to your claim within the time allocated to them under the family law rules, which if they're served in Canada or the United States, they have 30 days to file a response. So you're actually providing them with the copy or the documents that they can use to respond to your motion to change, and that's what's called a 14, or sorry, excuse me, a 15B. After the documents have been served, let's just say, for example, you don't use a process server, but you use another individual that's over the age of 18. After the documents have been served, the person who actually completed the service must fill out what's called a Form 6B, and that's an affidavit of service. And the affidavit of service is a sworn document that confirms when, where, and how the other party was served. And the server, whoever that may be, they must swear or affirm that this form, they must swear or affirm that in front of a commissioner for taking affidavits or a notary public. And that's often available at the courthouse or through your lawyer. You can find commissioners publicly as well as notaries that are public as well that they can also allow the process of the swearing to take place, the commissioning to take place. And then once you have proof of the affidavit of service, it's been sworn, you uh, take the complete copy of the motion to change documents, as well as the completed and sworn Form 6B, and all of these are filed with the same court that issued the original order. So it's the court who issued issued the motion to change in the first place. You take the completed and sworn Form 6B and all the materials that you served upon that person, and you file it with the same courthouse who issued you those documents in the first place. And again, you can do this in person at the courthouse, or as Michelle mentioned, you can do this online using the Justice Services online portal. Previously mentioned, but I'm going to reiterate it again. There is a timeline for the responding party to file what's called the response to the motion to change. And after service, so this is not once you've filed those documents with the court, it's the timeline only starts once they've actually received service of your issued materials. And again, if the responding party is in Canada or the US, they have 30 calendar days to respond. But if they are located outside of Canada and the US, they have 60 calendar days to respond. And some important reminders I like to give again, just to sort of recap what I've discussed. Regular service methods, as outlined in the family law rules, so that's mail, email, or fax, they do not apply to serving the initial motion to change. They may well be valid for other types of documents of service later on in your matter, but not for initiating the motion. There's also instances where a motion to change can be brought what's called without notice. So if there is reason for your motion to be brought without notice, and you are bringing a motion without notice, and this means that the other party won't be notified before a judge hears it. And this is done usually in protection matters or where there's a risk of the well-being and safety of either the moving party bringing the motion to change or the children involved. You don't serve the documents until after the judge makes an order. But there's certain times in which that process can be afforded and when that process can occur. And it's a very rare exception, and it's usually reserved again for urgent or emergency situations where providing notice to the other party would prejudice your case, or again, prejudice the safety of either yourself or children if they're involved. And um, with respects to the overall process itself, between when you get it issued to when there's a response, again, you have 30 days if the process is if the person's being served in Canada, the US, you have 30 days, and then at that point, there's other steps you can take. But right now we're just focusing on the actual process itself of how to serve. Golan, I know it's a mouthful. Golan, Michelle, any comments?
No, I don't want to be a person, a lay person that needs to go through all of these hoops. What I'm saying is that people have to realize that even though it's called a motion to change, it's really an originating process. It's a start of a legal proceedings, and as such, all the rules of initiating the process apply in terms of how you mentioned the service has to take effect, and the use of professionals is always a better way to proceed, at least at the beginning of the stages, to get everything into court and set up in such a way that if you decide that you want to proceed on your own, and at least the material is effectively before the judge. That's my comment on that, Joe.
Thank you. So, we've gone through the process of you as the moving party. You've properly served your documents, and now we're in that waiting period where we're waiting for a response. So, for example, Golan, if you're the lawyer for the client who is the moving party, what are you doing during those 30 days?
Well, the point of the matter, if you're going to be prepared for a response coming from the other side, is really to make sure that your initial motion has already included your arguments in anticipation of what the response would be. Now, if you followed our recommendation and you had that communication flowing beforehand, then essentially you would know what the essence of the objection or the opposition would be. Given that anticipation of opposition, the framework or the narrative of the motion to change would already cover those areas. One of the things that you have to realize is that in a motion to change proceeding, there's no option for reply to the answer. That's not part of the process. It's really a claim and then an answer. And then it's unlike a situation where you have an application, an answer, and then an option to reply. So in this case, you have to really anticipate and have it already on paper in terms of your anticipated opposition or reasoning why the change should not apply or not take effect. So that's the strategy in starting the case. Now, in terms of what do you do, it's really a matter of you can once the material has been served, and you can go more into that, Joe, in terms of that's where the alternative dispute resolutions may come in, because you just trigger that a process, and it may see, the other side may see, okay, it's serious now. It's not just he or she is not just it was not just hypothetical. Now it's a real thing that we need to address. So maybe we should do something different. So that's the opportunity to open another window of opportunity to mediate or negotiate.
100%. And I mean, you've already just prepared the segue for me into my topic, which is amazing. Thank you. And Golan's already reiterated this a couple times throughout the segment today, but going to court right away through a motion to change is not always, or should not always be, one person's first step in trying to resolve this. So, of course, parties, before proceeding with a motion to change or even contemplating going through this process, us as lawyers, we always advise, and it is really advisable to explore alternative dispute resolution methods to try to resolve this outside of court, even before engaging in the litigation sphere, in the litigation process. There's various ways in which resolution can occur. It can be as simple as both parties retaining lawyers and the lawyers themselves having a couple of exchanges back and forth, and it can be as simple as that, and amending and having an addendum, for example, to a separation agreement, or it can be terms that are negotiated to be incorporated into a consent motion to change, and that would then vary or change the original court order. So there's so many ways that resolution can be found without even commencing the motion to change in the first place. Another and obviously the most common method that our viewers are probably aware of is mediation. And for those that do not know what mediation is a voluntary, confidential process where a neutral third party, known as a mediator, they assist, two parties, disputing parties, in reaching a mutually acceptable agreement. And there's a lot of benefits to mediation. The first being cost effectiveness. More often than not, mediation is generally less expensive than going through the court proceedings. There's a great time-saving mechanism associated with it. You're really able, or if you can resolve disputes much faster than the traditional court process. As it relates, for example, to a motion to change, you have to spend the time with your lawyer or yourself preparing the documents. You serve those documents, they have 30 days to respond. Then you usually have to wait a month or two to get a first appearance, and that's in front of a clerk. And then on that day, you get your case conference date with a judge. So the entire span before you see a judge can be 4 to 6 months from once you serve the materials. So I mean, it takes a lot of time to get in front of a judge. So mediation is a great tool because you can, very well both parties can agree on jointly retaining a mediator, and you can be in front of that person within a week, trying to resolve your matter instead of waiting for a judge and speaking to them. There's the confidentiality aspect. So discussions and agreements. There are two types of mediation. There's open mediation and closed mediation. Closed mediation is exactly how it sounds. What occurs in those discussions cannot be used later in evidence as court. And if you do engage in closed mediation, that allows you to have the privacy of not airing out your family law matter with the general public. As soon as you enter the court process, your matter becomes public and it's able to be publicly viewed. So it provides a sense of confidentiality if you engage in closed mediation. Control is another benefit. Parties through alternative dispute resolution have a lot more control over the outcome. There's a lot more room for creativity as opposed to the general litigation process. So that's also a benefit. Um, and more often than not, it allows for the preservation of relationships between the parties. So mediation is a great tool as it encourages, cooperative problem solving. It allows you to be amicable. It allows you to be child focused. It allows you to be collaborative. There's a lot of great benefits that arise from mediation, and it doesn't allow both of you to take adversarial approaches that often becomes very stressful, very emotionally taxing. So there's some really great benefits to mediation. And what's really good about mediation is that it's available at many family court locations. It's often done through the Family Law Information Center, and more often than not, they'll actually have their own mediation office. There's also government funded services. So there's some services that are government funded and may either be free or they're offered on a sliding scale depending on your income. And what's really great about mediation is that there's never a bad time to mediate. So, parties can access mediation before the process occurs, or even if a motion to change has been initiated, parties can still engage in mediation, even though they're also in court as well. So the door is never closed to mediation. And clients sometimes have the question about when should they be considering mediation. If both parties are open to negotiation and there's a willingness to negotiate, that's always a positive sign. That's always a benefit sign. Again, if the parties are seeking a more amicable solution, and there's an appetite for a less adversarial resolution, that's always beneficial as well. And again, mediation is a great tool before the court proceedings even commence because it allows the parties to potentially resolve all of the issues or even some of the issues without court intervention, which saves a lot of, time and money associated with that. So, I mean, there are other mechanisms that can be implemented, such as mediation arbitration. There can be solely arbitration. There can be the retention of a parenting coordinator if there is already a court order or agreement in place that outlines a parenting plan and a parenting coordinator, assuming there's real no finances to be discussed or dealing with division of property or anything like that. A parenting coordinator is a great resource, and more often than not, they are usually trained as arbiters. So if the parties consent, they can allow the parenting coordinator to act as a mediator, so to speak, as first. And then if there's no traction or the parties aren't going anywhere, they can allow the parenting coordinator to arbitrate the issue. So, I mean, there's lots of great ways in which parties can resolve their dispute before even commencing the court process. Michelle Golan, any
No,
additions to that?
you covered it very thoroughly, I gotta say.
Nice. I'll take that as the win.
Yeah, I would
Yeah.
just add that the court also looks a little bit more favorably on people who have attempted to try mediation or any sort of outside of court resolution. It's a question on your documents when you go to your first court appearance. Have the parties attempted any settlement processes? So it's definitely something to consider. And if you can find some sort of resolution on any of the issues prior, like Joseph said, prior to getting to before a judge, it only benefits the parties.
For sure. So we do have a couple questions that have populated up here. Again, it deals with a question regarding material change. I'm just pulling one of the many that we have here. Someone asked, is retirement considered a material change even before 65 if an employee is eligible? Does anyone want to take a stab?
I can answer that. Sometimes it does, sometimes it doesn't, because the idea of material change is to consider whether at the time of making the order or the agreement, the retirement was already considered. So if it was considered, contemplated, then perhaps it's not a material change. On the other hand, it could be situations where, like this person suggesting that one is becoming eligible beforehand. Maybe it's an offer to retire with a better severance. This could be a situation that was unforeseen and maybe trigger a material change. So that again shows you that there could be a situation that potentially could trigger a motion to change. And when we're talking about retirement, we're normally speaking about a reduced income because of the retirement situation. And that reduced income could have an impact either on child support, on spousal support, or on both. So it's definitely something that need to be considered. It's definitely something that need to be analyzed in terms of the timing, the anticipation of that. When was the order or the agreement done? The same way that we're looking at a child parenting when he was 1 year old, it may not be the same when he's 10 years old or 12 years old. And at that point in time, it's not like we didn't anticipate that he's going to grow up, but we didn't think that is his or her interest would change to the effect that we're trying to achieve at this point in time. Same with retirement. All the circumstances surrounding the retirement and its effect on the existing order or agreement has to be taken into account here. So it's not necessarily a straightforward answer. It definitely has the potential to be a material change.
Perfect. That was a very comprehensive answer. Michelle, now we're just going to continue moving forward with the segment here. We get to the point where the parties are in court. You have your first appearance coming up. You have the Rule 39 appearance. What should a client or self-represented litigant expect?
Yeah. So Rule 39 appearance, as you've mentioned previously, it's not before a judge. It's in front of a Rule 39 clerk. It's purely procedural. So oftentimes we'll often attend on behalf of our client, as the client is not required to be there if they have someone attending as their agent. Basically what goes on in the appearance is the parties attend before the clerk and confirm that service of the motion to change has been carried out, service of the responding materials have been carried out, and if that's the case, then the parties can proceed to scheduling either their first case conference, or in some courts it's a first DRO case conference, which is before a senior lawyer and not a judge. If responding materials haven't been filed yet, it's an opportunity to attend before the court and seek consent for late filing, given circumstances beyond your control, etc. Basically, it's your chance to basically plea as to why you require additional time. Perhaps you were in the process of retaining a lawyer, and by the time you found one that was suitable for you, that left you with only a few days to file your response, or you're waiting on your tax returns to come back from the CRA, and you need those in order to file your response, so you need to consent for late filing. It's a good time to ask for it there. Generally, a first request for consent for late filing, as we'll tell our clients, is reasonable. If for whatever reason you don't obtain that consent for late filing from the other side, you'd be advising the court that you would have to be proceeding by a 14B motion, which is a procedural motion, to seek an order allowing you to late file your documents. But essentially, the Rule 39 appearance is very procedural. It's very straightforward, and there's no curveballs. The court clerk, I often find, is there to kind of help and guide self-represented litigants, and provide them with tips on how to get their materials filed, or how to communicate with our firm as well, and just to get everything done and moving forward, so that you guys, the parties, can get before a judge as well.
Perfect. Great answer. So Golan, we go through all these steps. We have the case conference, we attend. Maybe there's a settlement conference, we attend. And let's say that the parties don't make it to trial, because 97% of cases don't go to trial, and only 3% do, and the 97% get resolved. And the parties have a order on consent. Where do they go from there? How do they implement these new orders?
Well, it's again, depending on what the order is for. If, for example, it's a child support order that changes existing child support, it will go through the Family Responsibility Office. The whole process will be the same as the original order was made in terms of its enforcement. Of course, parties can opt out and continue with a arrangement. If they had a direct arrangement for payment, they can proceed with that, and just they go about implementing the order without any formality of the Family Responsibility Office enforcing anything here. The other scenario could be a change to the parenting. Well, you have a final, if the order is final, signed, issued, it means that it's now an enforceable order, and the new arrangement should take effect. The expectation is that the parties would follow and comply with the order. Any breach of that order obviously give rise to other proceedings of enforcement, contempt, and it doesn't look good on the party who may be in breach of the order. So in terms of implementation of a new changed order, there are the option of doing things on consent. In terms of payments, there is the option of proceeding through the Family Responsibility Office to enforce the monetary payments and deliver funds from the applicant, from the payor to the recipient. And in the in the sphere of the parenting, the expectation is that the parties will simply be abiding by the new parenting plan or schedule for parenting. And hopefully they will not resort to police enforcement or other agencies that may be required to intervene if one of the parties are not following the order. But the idea is that once you have an order, it's definitely the expectation that the parties will follow the order to the T.
100%. I mean, that's always the expectation. Sometimes we
Right.
get issues, but that's definitely the expectation. Um, it is 5:50. We do have a couple questions. I think there's one really good one here that I'd like to answer, or at least get everyone's roundtable discussion to answer. The question is, how can a separation agreement be structured to account for foreseeable changes and minimize future litigation? And I mean, we are talking about motions to change, so it'd also be, I guess, a good idea to discuss how we can prevent a motion to change from arising in the future. Michelle Golan, do you want to touch on this?
Well, I think it's a topic for another day, how to construe a separation agreement. That is the beauty of the abilities and expertise and experience of lawyers when they draft agreement. The generally speaking, we're talking about a a framework that the parties can foresee in terms of a age and stage of a child, in terms of a working and employment, anticipation of retirement, anticipation of a job loss, asking for a review to be already embedded in the agreement. That could be another way of making sure that we can come back and revisit some of the issues because we don't know what's going to happen a year from now, 5 years from now, 10 years from now. So these type of clauses are really have to be carefully reviewed and drafted. And that's the reason that, like I said, it's a topic for another day, but it's definitely, and
Yes.
it's an important question. I appreciate that, but it's not something that we can
No, it's definitely
kind of
it's something that requires
teach
definitely something that requires more thought,
as a
but
one. Yeah.
100%, 100%. So that really concludes our discussion for today. Thank you for tuning into
Excellent.
Family Law Now. Following the session, a brief survey will appear on your screen if you are joining us via Zoom, and that's allowing you to share your comments and suggestions for future topics you'd like us to explore. As always, your feedback is greatly, greatly appreciated. You're also able to book now to take advantage of this opportunity for a complimentary consultation with one of our lawyers here at Russell Alexander, as previously alluded to. In order to take advantage of such an opportunity, please contact our intake department at intake@russellalexander.com and provide the code LEAFS5, LEAFS5 to schedule your appointment. And that is because the Leafs are going to win tonight and they are going to advance to the second round of the
Go
playoffs.
Leafs go.
That's our code tonight, Leafs5.
Thank you, Joe. Thank you, Michelle.
Registration is now open for the next event, Common Mistakes Divorcing Couples Make and How to Avoid Them. In order to register, just please go to russellalexander.com/familylawnow. Thank you to our panelists. Thank you, Golan. Thank you, Michelle, for sharing your insights today. You're both so knowledgeable, and I know myself and our viewers take great well, really, I even take great pride in learning from you guys. You guys are great. You're both amazing. And to our viewers, thank you so much for tuning in today. And it is officially after hours. So thank you, everyone.
Go
Thank you.
Leafs. Let's
Go
go.
Leafs, go.
Good night.